This offence is 160 years old and can still get you sent to prison today for 2 years. But I'm willing to bet you haven't even heard of it, although it might be making a comeback. The offence is, wait for it, wanton and furious driving. Sounds like an aggressive offence, doesn't it? Sounds like a boy or a girl racer tearing up the streets, doesn't it? It sounds like those loud and obnoxious cars burning through the streets late at night, doesn't it? Well, no, actually, it's aimed at cyclists. That's right, the offence was created by Section 35 of the Offences Against the Person Act of 1861, and therefore it was before the advent of motor vehicles and other mechanically propelled vehicles. As such, it was only ever intended to be an offence against cyclists or other road carriage, but not mechanically propelled vehicles. So it's a fairly rare offence, but it can still be used today by the CPS when they're out of options when trying to prosecute somebody under any other sections of the Road Traffic Act. But as I said, it's mainly used against cyclists or riders of other non-mechanically propelled vehicles. Although don't get this confused with e-scooters, the rules for these changed earlier this year and they are considered to be a powered transporter, which covers a range of personal transport devices, all of which are mechanically propelled by a motor, and this includes e-scooters. So back to the offence of wanton and furious driving. The Offences Against the Person Act, Section 35 reads as follows. Whosoever having the charge of any carriage or vehicle shall by wanton or furious driving or racing, or other wilful misconduct, or by wilful neglect, do or cause to be done any bodily harm to any person whatsoever, shall be guilty of a misdemeanour, and being convicted thereof shall be liable, at the discretion of the court, to be imprisoned for any term not exceeding 2 years. So in other words, to convict you of this offence, the Crown must just prove that an injury was caused to another person because of the manner of your driving, typically when riding a pushbike. Although another reason you might face prosecution for this offence is if you are riding dangerously and cause an injury to somebody whilst on private land. Otherwise, typically offences would be prosecuted under the Road Traffic Act. Standard defences under such a prosecution would be to lay the blame with the other individual or the other party, although recent court cases have told us that this is unlikely to succeed. The other flat-out denial of the offence would be that the standard of your driving did not meet the threshold for wanton and furious driving. But as the penalty is only triable on indictment, that means it can and will only be heard in the Crown Court. You could be looking at a prison sentence of up to 2 years with an unlimited fine, although prison sentences for cases like this would probably be a last resort. But especially for those of you that are riding your bike around in parks or other private land and you collide with someone else causing serious injury or even death, this very old law may very well come back to haunt you. But back to modern times and modern law. Most offences are going to be prosecuted under the Road Traffic Act, and contrary to some of the comments on some of my videos, whilst some of the rules in the Highway Code are not worded as must or must not, breach of any other rules in the Highway Code, which you might think of as advisory, can and very often will be used against you to establish liability for a particular offence. So let's take a look at the Highway Code itself to see what it says about using these advisory rules when establishing liability. Many people believe that the Highway Code is not law, not legal requirements, and there are no criminal offences within. However, that's not exactly true. Even the Highway Code tells you that many of the rules in the Highway Code are legal requirements, and if you disobey these rules, you are committing a criminal offence. You may be fined, given penalty points on your licence, or may be disqualified from driving. In the most serious cases, you may be sent to prison. Such rules are indicated by the use of the words must or must not, and in addition, the rule indicates an abbreviated reference to the legislation which creates the offence. Now, as to those rules which are not must or must not rules, the Highway Code again clearly tells you that although failure to comply with the other rules of the Highway Code will not in itself cause a person to be prosecuted, the Highway Code may be used in evidence in any court proceedings under the Traffic Act to establish liability. I am here to tell you as a barrister that that is exactly the case. Courts will look at whether you have breached any rule of the Highway Code for whatever reason when trying to establish your liability. This includes rules which use advisory wording such as should, should not, or do, do not. Knowing and applying the rules contained in the Highway Code could significantly reduce road casualties. Cutting the number of deaths and injuries that occur on our roads every day is a responsibility we all share. The Highway Code can help us discharge that responsibility. And again, I'm here to tell you that the court is going to look at the Highway Code and any breaches of any of the rules, whether or not a criminal offence, when establishing your liability. If you enjoyed this video, please subscribe and hit the like button, and you might also enjoy this video here.